Welcome back to Really Legal. I'm attorney Ethan Bearman. Today was the first day of jury deliberations. I'll give you the good, the bad, and what's next. So the day started in Judge Mershon's courtroom in New York City with the judge bringing in the jury and the 6 alternates. So remember, there are 12 jurors, 6 alternates in case something happens with one of the other jurors. The judge made clear that the alternates are expected to continue attending even though deliberations are beginning. So he started the day with something I think is really important, and that these are the instructions from the judge to the jurors about what their job is. And this is actually, if you've never been through it before, this is actually a really important part. And I'm going to talk about this a little bit more today. Long before I became an attorney, I was on a kidnapping, torture, murder trial that involved drugs and was on the jury that had many days of testimony. We were sequestered during deliberations. So I speak to this not just as an attorney, but as a juror before I ever even went to law school. So, I can tell you when the judge in my case gave us these instructions, everybody around me took it very seriously. When you're sitting in that jury box and you're listening to a judge, it becomes apparent very quickly that for the overwhelming majority of people, I would suggest, including all 12 jurors on my jury, we took it very seriously. We took our job very seriously. So what does the judge instruct in a criminal case like this? Judge Mershon first talked about the idea that every juror has to be fair and impartial. We have to rely exclusively on what we were told in court, the evidence presented, and we're supposed to not consider things that were objected to and sustained, for example. We only could consider evidence that was entered into the record during the trial. And we can't let whatever bias we have allow us to dictate, how we deliberate and rule regarding the defendant. We have to, again, consideration of the evidence. It's anything that was stricken from the record has to be disregarded. So Judge Mershon talked about that today. Inference. This is a really important concept. People, I'm sorry to say, but lay people, and I, before serving on that jury as well, had it totally wrong on what evidence is admissible, how important it is. All evidence admitted into the record by the judge, allowed to be admitted into the record by the judge, carries equal weight. It's up to us to determine the validity, the believability, and how important it is proving the different elements. It's not somebody else's opinion that gets to tell us that, okay? And interestingly enough, things like circumstantial evidence that always gets downplayed in TV shows often is of equal weight in court, depending on different jurisdictions and whatnot. So inference is this idea that I can see something and I'm able to read into it what it might really mean. And the most common example, and as I understand from the reporting inside the courtroom today, Judge Mershon did exactly this too. You can determine that it's raining outside by seeing, or it rained outside by seeing people with umbrellas, galoshes on, and wet streets. That's an inference. So we tell the jurors, the judge tells the jurors that, hey, you can infer things from what was allowed to be entered into the testimony, into the evidence. Testimony included, whether it's physical evidence, verbal, testimony or whatnot. The burden of proof here, again, I believe right now you're going to see more right-wingers arguing about this. But the burden of proof in a criminal trial is beyond reasonable doubt. It doesn't mean beyond all doubt. It means the proof must be stronger than the probable doubt and not beyond all doubt. So I once had a law school professor back in, I think it was maybe my first year of law school, described it like this. They said it's like 90 to 95, maybe even 97% sure that the person is guilty, but it's not 98, 99, or 100%. So it's not a bright line rule. It's something that you have to go, wow, I really think the evidence shows that he's guilty, okay? Witness credibility, that is entirely up to you to determine what was credible and what wasn't. Accomplice testimony, right? So Michael Cohen is an accomplice. Jurors must view his testimony with caution. Like I said at the beginning of this trial, Michael Cohen is a difficult witness. It's no judgment of him in any way, shape, or form. But because he was an accomplice, because he has served time in federal prison, they can consider how much they want to believe him. And that's why the testimony of people like David Pecker was so critical in this trial. And that's why the testimony of the accountant person who talked about sending all the checks off to Washington, D.C. so Donald Trump could sign them, not Eric, not Don Jr., that was really important evidence to get into the record because it corroborates what Michael Cohen says. So I don't have to fully believe Michael Cohen, but David Pecker said the same or similar. Stormy Daniels maybe said same or similar. The accountant said same or similar. Now all of a sudden, yeah, I believe what Michael said about that. I don't have to believe him about certain things, but when there's corroborating evidence, now I might believe him more. So you have to know, and by the way, when we talk about beyond a reasonable doubt, it's for each element of the charges as described. The intent aspect, the intent to defraud must be considered, but premeditation is not necessary. So in other words, if Trump said, hey, talk to my guy, Michael Cohen, if he says yes, you know that that's true. And Michael Cohen and Donald Trump had just been talking about the election and these scandals with Karen McDougal or Stormy Daniels, potential scandals at that time. I can infer and I can determine that the intent was to defraud or to, change the outcome of the election. This is criminal. It has to be a unanimous verdict in New York, 12-0. So again, one juror can lead to a hung jury, which leads to a mistrial potentially. Among other things, it could lead to a complete dismissal. We don't know what's going to happen here. They could find him not guilty, too. I mean, it is still possible. I'm going to get to why I think that might not be the case. And then they're only supposed to talk to themselves, meaning each other. I can only talk to other jury members. So these jurors are not being sequestered. I was sequestered during my jury, and it was in the pre-smartphone days, by the way. So I couldn't talk to anybody. It literally was like, okay, you're locked away for a night. You can make a 5-minute phone call to your loved ones, and that's it. And you can't talk about the case. That's what these jurors are supposed to do. They're supposed to go home, not watch the news, not read the newspaper, not discuss with their family members any aspect of the case that is exclusively supposed to only be communicated with other members of the jury and nobody outside. But interestingly enough, this afternoon in New York, the jury asked questions. Before I get to that, one of the things I thought was really interesting here is in this case, and with Donald Trump's permission, by the way, the judge specifically asked defense counsel, does your client know about this and agree to it? They're getting a laptop with all of the evidence on it to review it themselves. It's not connected to Wi-Fi, according to the reporting, but they can review the evidence. So like in my case, we weren't able to review much evidence. We could only review our notes, and we could ask questions of things to be read back from the record or clarify jury instructions from the judge. And that's what happened here. The last question they asked today was a clarification of jury instructions. But more importantly, and I think this is what kind of tips us off for a little bit, the jury came back with 4 requests at 2:56 p.m. Eastern time. And I'm going to read these so I get it right. David Pecker's testimony regarding the phone conversation with Donald Trump. David Pecker's testimony regarding his decision not to finalize Karen McDougal's life rights. Easy for me to say. Number 3, David Pecker's testimony regarding the Trump Tower meeting, where he specifically in testimony said that Donald Trump talked to Michael. He'll know that it was approved by me. That is literally the assignment of an agent under different aspects of the law. That is a very important piece of testimony from David Pecker. And then number 4, Michael Cohen's testimony regarding that same Trump Tower meeting. So they want to compare. Is Cohen telling the truth? Are they corroborating? Are they saying same or similar so we can form a judgment out of that? This is, by the way, they didn't ask anything about the business records thus far. And I got to just tell you, at least in my experience, when we went back to start deliberating, it was like, okay, how are we going to do this? Okay, let's lay out what are the elements, right, of the crimes that they're accused of in the case that I was in. And then, all right, we got to start arguing what was the evidence that we heard and understood that matches to these elements that the judge gave us to deliberate on. But if they're already asking that quickly about the very specifics that would show Trump's intent to commit what makes these charges felonies, the intent to change the outcome of the election, to have an impact that would have this outcome that has an impact on the election. Again, he doesn't have to have committed the crime, just the intent to commit. They didn't ask anything about the business records. This tells me that the jury most likely has already made up their minds regarding the business records. These are false business records. As I've been saying, this is almost prima facie. It's a false business record. He didn't do anything that was a legal expense, therefore you falsified the business record. That alone is a misdemeanor under the New York law. However, to make it the felony, which is what DA Bragg is pushing so hard for, you've got to show the intent, and those jury questions really show me, along with the judge's instructions, really point me that they're already at the stage of, did he have the intent to violate New York election law 17-152 or not? So they're already along the process is what that tells me. I don't know anything for a fact, but this is my intuition and my experience telling me this. Also, importantly, people love to argue over a fast return means he's guilty. A slow return means a hung jury. Anything less than 3 days, no way for me to know for sure if he's guilty or not. At this point, they've deliberated for the afternoon. They were sent home for the night. It's not a quick not guilty. They are definitely deliberating. If it goes more than about 3 days, could be an acquittal, could be a hung jury. That could cause a problem. But that's what I'm going to be watching out for, is if they don't hand the verdict back by the end of the day on Friday, then I would start getting concerned over whether or not this is going to be a hung jury or they're going to just straight up find him not guilty. So what do you think? Give me your comments below. I love your comments. You got to know that. And please share the video with everybody you know. Don't keep it to yourself. All right. The good, the bad, what's next? The good. Jury's in deliberation. They're asking the right smart questions. That actually is a good sign to me. The bad, I don't see any real bad at this point. I just don't. I mean, I guess you could look at it through the lens of they didn't find Donald Trump guilty yet. I don't view that as bad. If they come back too fast, I would be worried, I guess. And so what's next? Jury deliberations tomorrow. Possible more jury questions that would give us an indication of what's going on. By the way, I have a question for you. Totally separate topic for a second before we wrap up today. On TikTok, there's this trend of telling ghost stories. I have one. Do you want me to tell it over on TikTok? Follow me there. Or on Instagram. I'm Ethan Bearman on Instagram, Ethan Bearman ESQ on TikTok. Just comment below. Let me know if you want to hear that ghost story too. I have a good one, and it's pretty interesting. Anyhow, love you guys. Thank you so much for watching all the way through. Click the like button, smash that subscribe button. Please share with as many people as you can and help support the Really American Network. I'm attorney Ethan Bearman. This is Really Legal on the Really American Network.